Hey everybody, welcome to Guns and Gadgets, the premier source for Second Amendment news, and do I have something you need to see today? I want to tell you that the government has just filed their filing to the United States Supreme Court in the bump stock case. That's the Garland v. Cargill case. And woo, they admit in this filing that they've just changed things without congressional laws to affect what you and I can own. And it's there. They also have one bold-faced lie in there that I want to tell you about. Stand by. So here on this screen is the filing, and here is the question presented to the United States Supreme Court in this case. Federal law has long restricted access to machine guns. A machine gun is defined as any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger, as well as a part designed and intended solely and exclusively for use in converting a weapon into a machine gun. A bump stock is a device designed and intended to permit users to convert a semi-automatic rifle so that the rifle can be fired continuously with a single pull of the trigger, discharging hundreds of bullets per minute. The question presented is whether a bump stock is a machine gun as defined in 26 USC 5845 Bravo. What I'm going to show you next is some legalese. Stick with me because I want you to understand why we're here. I think it's important everybody know what the government is saying, what the law says, what the definition is, and you tell me as we proceed here what you think is going to happen. This is great, and then I'm going to tell you where, show you where they say, hey, we changed things because we're the DOJ, we're the ATF, and Trump told us to do this. And I'm also going to show you their bold-faced lie, which is disgusting, yet shocking. Here we go. The legal background. Under federal law, a machine gun is a firearm that fires repeatedly with a single pull of the trigger. In other words, once the shooter depresses the trigger, the machine gun continues to fire until the shooter releases the trigger or exhausts the ammunition. Such weapons are also commonly called automatic or fully automatic firearms. A machine gun differs from a firearm with a manual action. That is, a firearm that requires the shooter to take a manual step, such as moving a bolt or lever to eject a spent cartridge and load a new one before firing an additional shot. It also differs from a semi-automatic firearm, that is, a firearm that automatically loads a new cartridge once the previous cartridge has been fired, but that fires only one shot with each pull of the trigger. Machine guns facilitate rapid fire by eliminating the manual steps that the shooter would otherwise need to repeat in order to fire multiple shots. Machine guns were originally developed in the late 19th century for use in battle, but in the late 20s and early 30s, gangsters began using them in their criminal activities. John Dillinger used machine guns to rob banks. Pretty Boy Floyd used them to ambush policemen, and Al Capone's henchmen used them to murder rivals in the St. Valentine's Day Massacre. Congress responded with the National Firearms Act of 1934. That statute required the registration of machine guns and taxed their transfer. Those provisions reflected Congress's judgment that the gangster, as a law violator, must be deprived of his most dangerous weapon, the machine gun, and that there is no reason why anyone except a law officer should have a machine gun. Congress amended that statute in the Gun Control Act of 1968. The Gun Control Act expanded the National Firearm Act's scope, overhauled its registration requirements, and strengthened its criminal penalties. Those changes were part of Congress's effort to address the increasing rate of crime and lawlessness and the growing use of firearms in violent crime. Congress further restricted machine guns in the Firearm Owners Protection Act. That statute amended Title 18 of the U.S. Code to make it a federal crime to transfer or possess a machine gun, but a grandfather clause exempted machine guns that were lawfully possessed before the date the criminal prohibition took place. Together, these provisions effectively froze the number of lawful machine guns in private hands at the level that existed in 1986, thanks to Ronald Reagan. Congress took that step to provide more effective protection of law enforcement officers from the proliferation of machine guns. Okay, so wanted you to see the advancement or de-escalation of freedom, the recession of freedoms related to machine guns, okay? We were totally free, and then we had to stop Al Capone and Pretty Boy Floyd, so we took away a certain type of gun, and then we restricted it even more that citizens couldn't have them or transfer them, and unless it was before 1986. Okay, Ronald Reagan signed that into law. So here we are. But where's the bump stock come into play? Check it out. The Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF, an agency in the Department of Justice, issues guidance about the definition's scope. ATF encourages manufacturers to submit novel weapons on a voluntary basis so that it can assess whether they qualify as machine guns. That process enables the agency to provide the manufacturer with ATF's official position concerning the status of the firearm under federal firearm laws. Classifications are, however, subject to change if later determined to be erroneous or impacted by subsequent changes in the law or regulations. Well, there's been no changes in the law. There's been no changes in regulations, just ATF's actions. Let's get into the bump stock. This is what the government's telling the Supreme Court. A bump stock is a device that modifies a standard semi-automatic rifle. A standard semi-automatic rifle fires only one shot each time the shooter pulls the trigger, but a bump stock converts it into a weapon that can discharge hundreds of rounds per minute after a single activating action. Rifles equipped with bump stocks are estimated to fire between 400 and 800 bullets per minute, a rate of fire comparable to common military machine guns like the M14 and M16. ATF first encountered bump stocks in 2002, when it received a classification request for a device known as the Atkins Accelerator. The Atkins Accelerator operated much like the type of bump stock at issue here. The shooter would initiate a bump firing sequence by pulling the trigger once, causing the rifle to fire a shot, recoil, and slide backwards in the stock. Unlike the type of bump stock at issue here, the Atkins Accelerator relied on internal springs rather than on forward pressure maintained with the shooter's non-trigger hand to force the rifle to slide forward again. The recoil and the spring-powered device thus caused the firearm to cycle back and forth, impacting the trigger finger without further input by the shooter. According to its advertisers, the Atkins Accelerator enabled the shooter to fire approximately 650 rounds per minute. ATF first declined to classify the Atkins Accelerator as a machine gun. The statutory definition asks whether the weapon can shoot more than one shot by a single function of the trigger. And the agency read the term single function of the trigger to mean single movement of the trigger. The classification rested on the agency's understanding of the device's theory of operation. Although the agency tried to test fire a prototype of the Atkins Accelerator, the prototype broke during the testing. Okay, so the first version of bump stock was submitted, and they said, nope, not a machine gun. That's key. 4 years later, in 2006, after further review of the device based on how it actually functioned when sold, the agency reclassified the Atkins Accelerator as a machine gun. In the course of doing so, it determined the best interpretation of the phrase single function of the trigger includes a single pull of the trigger. So ATF just said right there in plain English, black and white, you know what, Supreme Court justices, the law, the definition says single pull of the trigger, but we changed it to say single function of the trigger so that we could ban this device. They just said it. But it keeps going. ATF observed that when a semi-automatic rifle is equipped with an Atkins Accelerator, a single pull of the trigger initiates an automatic firing cycle that continues until the finger is released, the weapon malfunctions, or the ammunition supply is exhausted. The device's inventor sought judicial review, but the 11th Circuit upheld ATF's decision, blah, 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 blah. When ATF reclassified the Atkins Accelerator in 2006, it advised owners of the device that removal and disposal of the internal spring would render the device a non-machine gun. The statutory definition asks whether the weapon can shoot automatically more than one shot. The agency reasoned that without the spring, the Atkins Accelerator would not function automatically. ATF soon received classification requests for bump stock devices that did not include internal springs, but instead required the shooter to maintain constant forward pressure on the barrel or front grip in order to cause the firearm to slide forward after recoiling. In 10-letter rulings between 2008 and 2017, the agency concluded that such devices did not enable the firearm to fire automatically, and thus did not convert weapons into machine guns. So for 9 years, the ATF, after the Atkins accelerator, for 9 years, they told everything that was submitted, all the manufacturers, that's not a machine gun. Nothing's changed other than who's in charge in the corner office and the agenda that they're trying to push on disarming American citizens. I've said before in many videos, I have used bump stocks at many events during the years, and you pull that trigger and hold it to the rear, it does not continue to fire. Single function of the trigger. You have to do other things to make it fire consistently, and that doesn't mean you're going to find that sweet spot where it works. If you pull the trigger to the rear and hold it, one shot goes off. Not a machine gun. To the letter of the definition, which the ATF is supposed to follow, not change. Check this out. In October of 2017, a gunman used rifles equipped with bump stocks to commit the deadliest mass shooting in American history. In a matter of minutes, the bump stock devices allowed the shooter to fire more than 1,000 shots into a large crowd attending an outdoor concert in Las Vegas. At times, the shooter's firing rate reached 9 rounds per second. The attack killed 58 people and wounded approximately 500 more. And that is their bold-faced lie. The worst mass shooting event, tell me down below if you think I'm right, is actually called Waco, where the United States government, the ATF included, shot and killed Americans and then burned the rest alive, to include 28 children. That is your government doing that to you. Yeah, that's their lie. They never want to say what they've done. They'll never tell you that they ran guns into Mexico, and those guns ran into Mexico ended up killing a Border Patrol agent. They won't tell you about Ruby Ridge. They want to say that you guys and gals watching, you're the bad people. You need to be restricted, not the government. Let's keep going. After the Las Vegas attack, ATF decided to conduct notice and comment rulemaking to reconsider its position on bump stocks. The agency initiated the process by issuing an advance notice of proposed rulemaking seeking information about the devices. President Trump then issued a memorandum directing ATF to complete the rulemaking process expeditiously, and the agency ultimately published a final interpretive rule in December of 2018. Before the rulemaking, ATF's relevant regulations had simply repeated the statutory definition of the term machine gun. That's what they were required to do. The final rule amended those regulations to reaffirm the agency's view that single function of the trigger means a single pull of the trigger and analogous motions. The agency explained that it had interpreted single function of the trigger to include a single pull of the trigger since reclassifying the Atkins accelerator in 2006, and that it previously applied that interpretation to classify a variety of other devices as machine guns. Except it didn't use it on any other bump stock that was submitted to them for classification. They got caught. They just told the Supreme Court, yeah, we lied. Yeah, we changed the rule. Yeah, we don't follow the statutory definition set by Congress that we're supposed to follow. We changed things because it made us feel better. We created a rule. Stop me if you've heard this before. We created a rule to change things so that we can take more guns from the public, even though Congress hasn't taken that action. We've taken that rule based off of different presidents, to include Barack Obama, Donald J. Trump, Joseph Biden, to take guns and associated accessories from the public. So guys and gals, I want you to be aware of what's going on here in this case. Why? Because I believe that this case, this Cargill case, is going to be the one that destroys the ATF. That's my personal belief. Now everybody's saying right now, well, the Supreme Court didn't take New York, and the Supreme Court didn't take Illinois. Guys, as much as it pisses all of us off, myself included, that's just not how they operate. They wait until cases are done, and then they get appealed to the Supreme Court for a writ of certiorari as petition. And then they decide if they're going to take the case or not. It's just how it works. It's how it's designed, you know. But this case, the Cargill case, coming soon. You'll have your decision, and it's going to rock the ATF to the core, I believe. And don't forget, they also have a case coming out that's going to address Chevron deference, which is how the ATF does what it's been doing. All these rules, right? Chevron deference, that case created a scenario where if an agency, if a rule is vague, right, and there's confusion in that rule, like frames and receivers, bump stock rule, blah, 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 then the legal structure gives deference, they give deference to the agency, here ATF, tasked with enforcing those rules, regulations, and laws. But here, the ATF's changing things, hoping, thinking, praying that they'll just get that deference and they can change laws, even though they can't, they don't have that authority. Read the Constitution for those typing. And hoping that they can change the course of liberty, individual liberty, without anybody noticing. We've noticed lawsuits are being lodged. Their hope is that it stops there. Because if we were the problem, Mr. and Mrs. America, with 100 and whatever the number is today, 125, 150 million gun owners, with several hundred million guns and billions of rounds of ammunition, like if we were the problem, people would know it. But the government knows we're the problem. If they choose to push to communism, we are the problem. Let me know what you think down below, guys and gals. Wanted you to know what the government has done. They're in their filing. They've admitted that they've changed things. I think it's going to come back and bite them in the keister. Hope you have a phenomenal day. Be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. Subscribe to this channel for more information like this and filings. Anything from litigation to legislation, I will keep you in the loop. All you got to do is hit that subscribe button down below. Have a great day, y'all. Take care.